This is Barry Zalma speaking for Claim School Incorporated's Zalma on Insurance blog. Today's blog deals with why a small fraud defeats an entire claim, and that even the attempted withdrawal of the fraudulent portion of a claim proved by the defendant does not eliminate the effect of a fraudulent claim. In Star Casualty Company v. Gables Insurance Recovery, a July 20, 2022 decision of the Florida Court of Appeals, Star Casualty Insurance Company appealed a summary final judgment and attorney fee award entered in favor of Gables Insurance Recovery, Inc. as assignee of Star Casualty's insured Maria Correa. Star Casualty alleged that the trial court erred by granting summary judgment due to genuine issues of material fact concerning whether Correa's medical bills for diagnostic imaging procedures were medically necessary and related to the underlying accident for purposes of Section 627.736 of the Florida Statutes. Additionally, Star Casualty alleged that the trial court reversibly erred by striking 4 affirmative defenses from its amended answer that could have exempted it from liability for the claim. Correa was involved in a vehicle accident on January 19, 2009 and sustained injuries. Subsequently, Correa received diagnostic imaging procedures costing a total of $3,375, and Gables, as her assignee, submitted a claim to the insurer for reimbursement of 80% of the reasonable medical expenses pursuant to the statute. After the insurer paid only $400.71 and denied the remainder of the claim, Gables sued to recover the remaining costs. Star Casualty proffered an affidavit of Edward A. Dower, M.D., opining that the charges were not medically necessary or related to the accident. The affidavit also noted that 3 of the imaging procedures performed on Correa appeared to have been improperly upcoded or unbundled with other procedures. Based on Dr. Dower's affidavit, Star Casualty also amended its answer to add affirmative defenses, asserting that it was exempt from paying the entire claim because the 3 charges were fraudulent, upcoded, or unbundled. Prior to the summary judgment hearing, Gables voluntarily withdrew its claim for reimbursement of the 3 charges Star Casualty based its affirmative defenses on. Gables then moved to strike the defenses from Star Casualty's answer, alleging that the withdrawal of the claims for those 3 charges made the corresponding defenses irrelevant and moot. The trial court, concluding that Dr. Dower's affidavit related solely to the reasonableness of the charges and did not create any genuine dispute of material fact as to the relatedness and necessity, granted partial summary judgment on the relatedness and necessity issues, and granted Gables' motion to strike the affirmative defenses. Star Casualty then stipulated to the remaining issues of reasonableness, and the court entered a final judgment and an award of attorney's fees and costs in favor of Gables soon thereafter. The Court of Appeal noted in its analysis that the trial court erred by finding that Dr. Dower's affidavit did not create a genuine issue of material fact. An issue of fact is genuine for summary judgment purposes when a reasonable jury could potentially return a verdict in favor of the non-moving party. A factual dispute is material when it may affect the outcome of the case under the applicable substantive law. The sole basis for Star Casualty's assertions of a factual dispute as to relatedness and necessity comes from Dr. Dower's affidavit. In the affidavit, Dr. Dower opines that the images conducted were not medically necessary and not related to the accident, because there were no objective findings and documentation to warrant the ordering of the X-rays in this case. Because these findings created a genuine issue of material fact as to relatedness and necessity, the summary judgment must be, at the opinion of the Court of Appeal, reversed and remanded. The Court of Appeal also instructed the trial court that on remand, its order striking Star Casualty's affirmative defenses must be reversed, as to the defenses were not wholly irrelevant to the claims in the operative complaint. An affirmative defense may not be stricken merely because it appears to judge that the defendant may be unable to produce evidence at trial to sustain such a defense. The trial court's reasoning for striking the defenses was based solely on the fact that the claims for reimbursement of the charges relating to those defenses had been voluntarily withdrawn. Conversely, Star Casualty claims that because the defenses asserted fraud, upcoding, and unbundling, such defenses pertain to the remaining charges. Any insurance fraud voids all coverage arising from the claim related to such fraud under the personal injury protection coverage of the insured person who committed the fraud, irrespective of whether a portion of the insured person's claim may be legitimate. An insurer is not required to pay a claim or charges that are inter alia upcoded or that is unbundled when such treatment or services should be bundled, and Florida statutes relieve both the insurer and the insured from paying the claims of any person who knowingly submits a false or misleading statement relating to the claim or charges. Evidence of insurance fraud necessitated summary judgment in favor of a provider as to the entire PIP claim, comprising two separate and distinct claims for medical expenses and lost wages, since allowing for payment of one portion of a claim would nonsensically allow an insured to engage in a cost-benefit analysis with respect to the contemplation of such fraud in the arising from and relating to language in Section 627.736 clearly seeks to encompass all claims pertaining to a single event resulting in purported losses. A party seeking insurance benefits may not commit a little fraud any more than he or she can be a little dead. When caught in a fraud, as evidenced by an expert, the fraud attempt cannot be ignored by simply deleting it from the claim, since the insurer, by proving some fraud, will probably be able to convince the trier of fact that the entire claim was fraudulent, or that the attempted fraud voided the right to the benefits of the policy. You just cannot commit a small fraud, and you can't avoid fraud by removing a claim for that which the insurer's expert proved was fraudulent. This video was adapted from my blog, Zalma on Insurance, which is available at www.zalma.com/blog, which you can subscribe to and get by email every day it is published. Thank you for your attention.